Okay, there we go. All right, I'm going to go ahead and call the meeting of the Committee of the Whole for Tuesday, July 10th, 2012 to order. Will the clerk please call the roll?
Calling the roll, Ms. Conwell? Here. Mr. Jones?
Here.
Mr. Rogers? Here. Ms. Simon? Here. Mr. Greenspan?
Here.
Mr. Miller?
Here.
Mr. Brady?
Present.
Mr. Germana? Mr. Germana is absent at the moment. Mr. Gallagher?
Here.
Ms. Connolly? Here. We have a quorum.
Very good, thank you. Has anyone signed in for public comment relating to the agenda?
Oh, I'm sorry. I missed Mr. Schron. Sorry.
Oh.
So I'm going. Here.
Has anyone signed in for public comment?
Mr. Chair, no one has signed in.
Very good, thank you. In front of us are the minutes from the June 26th, 2012 meeting. I'll entertain a motion to approve the minutes.
Second.
Motion's been made and seconded. Any discussion on the motion? Hearing none, all in favor of approving the minutes of June 26th, signify by saying aye.
Aye.
Any opposed? The meeting minutes are approved. Okay, before I begin, I just wanted to kind of outline here. The purpose of our meeting today is to hear, discuss, debate, and move the 7 resolutions presented to the Cuyahoga County Council Committee of the Whole. Our mission is quite clear, as Council President Conley articulated in her April 25th meeting, or memo, in which she said we're doing this in 2012 for 2 reasons: cost and clarity, as far as bringing forward the proposals. In that same letter, Council President Conley went on to say the Council's 2012 process is a limited one, focusing on items that are important and urgent enough for action now. To summarize, actions today should be focused on items that we believe will provide clarity to the current charter and are urgent enough to require attention today. We should focus our deliberations and ask ourselves the question on each of the resolutions. Does this matter provide clarity, and is this matter so urgent the clarity sought in the resolution merits its consideration by the electorate this November? We're going to move forward with the procedure today, somewhat different than we've done in the past, but the procedure will move as follows. The clerk will read each item individually into the record. The sponsor will then have an opportunity to provide a brief explanation as to the resolution. Discussion will be in the form of public comment on each item. The sponsor will have an opportunity to address the comments raised if they so desire, and then the committee members will move forward with its discussion. At that time, a motion will be entertained in one of the 3 forms. Number 1, is this an item that this committee wishes to refer to second reading to the full council on July 24th? Is this an item the committee wishes to refer to the Charter Review Commission? Or does the committee wish to make no action or take no action on the item? I think it's important to note that these discussions have been very helpful in openly debating the subject matter, so that the item, should it reach the ballot, will have had its open air discussions within this committee. And I'll make a statement now, and I'll make the same statement at the end. We should encourage members of the public to serve and to apply to serve on the Charter Review Commission, which will be paneled in September. So with that being said, we'll go ahead and ask the clerk, if the clerk would please read the subject to the first resolution into the record.
Resolution number 2012-0097, a resolution providing for submission to the electors of the County of Cuyahoga an amendment to Article 2, Section 4, and Article 3, Section 7 of the Charter of Cuyahoga County, and declaring necessity that this resolution become immediately effective.
Very good, thank you. Is there any public comment relating to this item? Hearing none, Councilmember Miller, as the sponsor of this resolution, would you please provide comment?
Mr. Chairman and my colleagues, we discussed this resolution in considerable detail at the last meeting, and what it does is that it deals with some unclear language in the charter, where the charter says that if a vacancy occurs in the first or second year, a 4-year term, that then an election will be held for the remainder of the term. but this could create logistical problems if that vacancy occurred late in the second year, and the amendment was designed to correct that situation. There were some comments about this amendment in the daily newspaper this morning, and I would like to point out that the current charter language relies heavily on appointments to fill vacancies. The language of this amendment merely corrects logistical problems without changing the basic structure. The major alternative would be to make greater use of special elections, which also has issues, namely higher costs and lower turnouts. That having been said, the comments that my colleague Councilman Brady made at the last meeting are well taken, and I think it makes sense that rather than make a narrow fix now, we should have the broader discussion about special elections, which is beyond the scope of the 2012 amendment process. Therefore, at the appropriate time, I'm going to make a motion that we refer this amendment to the Charter Review Commission with the suggestion that they consider both a narrow fix, such as is in this proposal, and that they also consider whether we want to move to a broader use of special elections.
Okay, thank you. Mr. Miller, there's a motion on the floor to move this item to the Charter Review Commission. Is there a second? Second. Motion's been made and second. Is there discussion on the motion? Hearing none, if the clerk will please call the roll on Resolution 2012-0097.
Calling the roll on Resolution number 2012-0097. Ms. Conwell? Yes. Mr. Jones?
Yes.
Mr. Rogers? Yes. Ms. Simon?
Yes.
Mr. Greenspan?
Yes.
Mr. Miller?
Yes.
Mr. Brady?
Yes.
Mr. Gallagher?
This is to move it to the Charter Review Commission.
No.
Mr. Schron?
Yes.
Ms. Connolly?
Yes.
Carries.
Very good, thank you. Will the clerk please read the next item on the agenda, Resolution 2012-0098?
Resolution number 2012-0098, a resolution providing for submission to the electors of the County of Cuyahoga an amendment to Article 3, Section 10, subsection 5 of the Charter of Cuyahoga County, and declaring the necessity that this resolution become immediately effective.
Very good, thank you. Is there any public comment relating to this resolution? Hearing none, will the sponsor please provide comment?
Mr. Chairman and my colleagues, the Charter states in Article 3, Section 9 that all powers of the Council shall be exercised by ordinance or resolution, and states in Article 3, Section 10, subsection 5, that each ordinance or resolution shall be promptly presented by the clerk of Council to the County Executive for approval or disapproval. Taken together, these sections clearly suggest that the Executive is to review all Council actions. However, there are clearly actions for which executive review either is not or should not be required. This amendment creates exceptions for the following list of items. Number 1, Council rules and order of business. Number 2, scheduling of Council and committee meetings and other internal actions of Council. 3, setting the structure of the Council office and Council office hiring. 4, contracts for Council office operations. 5, confirmation of executive appointments. 6, appointments designated to be made by Council. 7, use of the Council's charter investigatory powers. And finally, submission of charter amendments to the voters per Ohio Constitution language. I believe that this is a significant problem that needs to be addressed. However, Council President Connolly and the Law Director have expressed doubts over the need for this amendment, and the Law Director has proposed alternative language. Therefore, what I'm going to move is that we apprise the Charter Review Commission of the problem created by the language in Article 3, Sections 9 and 10, without suggesting a specific solution to see what they come up with. So that would be my motion.
Motion's been made and seconded. And just for point of clarity, this is similar to the item, similar action that the Charter Committee moved on an HRC item, one of the original 10, correct, Mr. Miller?
That's correct.
Very good. Okay, there's a motion and second to submit this item to the Charter Review Commission for further clarity. Is there any discussion on the motion? Hearing none, would the clerk please call the roll on Resolution 2012-0098?
Ms. Conwell?
Yes.
Mr. Jones?
Yes.
Mr. Rogers?
Yes.
Ms. Simon? Mr. Greenspan?
Yes.
Mr. Miller?
Yes.
Mr. Brady?
No.
Mr. German? Oh.
What?
I don't know what the issue is. Pass.
The record reflect that Mr. Germana is now in attendance.
I would make a recommendation that we not recognize until the vote is complete.
Okay. Mr. Gallagher?
Yes.
Mr. Schron?
Yes.
Ms. Connolly?
Yes.
Motion carries.
Mr. Chairman,
Yep, Mr. Gallagher.
I would like to change my vote on 97. I incorrectly voted no. I should have voted yes.
Okay.
Do our,
Defer to Mr. Miller as to the protocol for changing a vote.
Is this on this vote or the previous?
No, the previous vote.
Unfortunately, the vote has already been announced. It would not be allowed under the rules. We would have to move to suspend the rules to allow it. And I would make that motion.
Look, before we move there, is this under motion to reconsider? Or is that the rules in which we're going to?
We could move to reconsider, or we could simply suspend the rule and allow the vote change to be made.
I'm going to second that motion to, did you make a motion to suspend?
Yes.
Okay, so there's
I second
a
that.
second to suspend the rules. Which rule are we suspending in order to?
I don't remember by number.
Okay.
Sorry.
All right, hold one minute,
It's
please.
in section 10, I believe.
Well,
We just do a motion to reconsider?
Okay, withdraw my second.
10D. Rule 10D.
okay, so do you keep your second? Okay, so there's a motion to suspend Rule 10D. All in favor of, well, is there a discussion on the motion? Hearing no discussion, we'll take a voice vote to suspend the rules, Rule 10D. All in favor signify by saying aye.
Aye.
Okay, all opposed? Okay, the rules are suspended to allow for for Mr. Gallagher to amend his vote.
I'd like to vote yes on 97.
Okay, very good, thank you. That rule has been suspended and the vote has been recorded.
Thank you, Mr. Chairman. I apologize.
Very good, thank you. Moving on to agenda item Resolution 2012-0099. Will the clerk please read that motion, or that resolution?
Yes, but first I would like to officially recognize the attendance of Mr. Germana.
Very good, thank you.
Guys, I just could not get into the Justice Center, and I was locked in gridlock because of the bomb square across the street. So I finally was able to get into the Huntington garage.
Okay, very good. That bomb scare is not on the agenda, so we'll not be discussing it today. Okay, will the clerk please read the next item on the agenda?
Resolution number 2012-0099, a resolution providing for submission to the electors of the County of Cuyahoga an amendment to Article 6, Section 2 of the Charter of Cuyahoga County, and declaring a necessity that this resolution become immediately effective.
Okay, very good. Is there any public comment relating to this resolution? Hearing none, Mr. Miller, as the sponsor of this resolution, would you please provide comment?
Mr. Chairman and my colleagues, this amendment deals with the Board of Revision, and once again, I would like to thank my colleague, staff colleagues Joe Nani and Trevor McAleer and Joanne Gross for a tremendous amount of help, research, and assistance, without which this amendment could not have been properly prepared. The new boards of revision have performed admirably in hearing cases, reducing the backlog and restoring confidence in the process. However, there are serious structural problems in the Charter's language about the Board of Revision. The Charter language says, "There shall be one or more boards of revision," and then goes on to describe what we know as hearing boards. The Board of Revision itself is not mentioned. This raises serious questions as to how the process is to be administered. So the first thing this amendment does is to distinguish between the statutory Board of Revision and the hearing boards. The Ohio Revised Code comprises the Board of Revision as the county auditor, the treasurer, and one county commissioner. Rather than making a literal translation of officers, this amendment tracks the ORC's intention of separation of powers on the board, and it comprises the statutory board as the executive, the fiscal officer, and one member of council appointed by the council president. The second paragraph of this amendment clarifies authority for the administrative procedures of the Board of Revision, which is lacking in current language. The statutory Board of Revision is tasked to develop its own rules and procedures consistent with the Charter and general law. The statutory board is also directed to appoint and set compensation for an administrator and other assistance as needed, consistent with the county's operating budget. The administrator is given responsibility for the office operations of the Board of Revision and the hearing boards, including setting the hearing schedules. The Board of Revision is then given the power to create and appoint members to one or more hearing boards. The hearing boards are given the same powers to hear complaints on property valuations as are given to boards of revision hearing boards under general law, which means that a decision by the hearing board is the decision of the Board of Revision, and any appeals would be to the courts and not to the statutory Board of Revision. The Board of Revision is directed to determine qualifications for hearing board members to assure that they are skilled in appraisal, real estate, and/or law, but the exact specifications are left to the Board of Revision. The political party limitation on hearing board composition found in current language is eliminated. The Board of Revision appoints the hearing board members subject to confirmation by council, with council action required within 30 days. The Board of Revision is also given power not expressed in current language to make appointments for unexpired terms to fill vacancies, also subject to confirmation. As in current language, the term for the hearing board members is for 3 years. 2 exceptions are added. First, the Board of Revision is empowered to create temporary hearing boards with a term of up to 1 year to clear backlogs or anticipate heavy workloads. Second, the Board of Revision is directed to adjust hearing board terms so that the ending date of the various hearing boards is staggered. These 2 changes should enable better planning and workload management. Under the current system, we could have a situation where a Board of Revision hearing board would be required to remain in place even though there's not a sufficient number of cases. The council is tasked to develop a compensation plan for hearing board members, but the Board of Revision itself will set the compensation for hearing board hires within that plan. The hearing board members are designated as full-time, unclassified employees of the Board of Revision. Finally, this amendment provides for the removal of hearing board members when necessary. Such removal must be for cause requires approval by the Board of Revision and confirmation by council. I believe, harking back to what was said about the issue of clarity, that this amendment does clear up a lot of confusion, and there is a certain sense of urgency because the Board of Revision operates on a daily basis and it needs to operate under clear charter language. And so I strongly urge my colleagues to place this amendment on the ballot, and at the appropriate time, I'm going to move that it be referred to the full council for second reading.
Very good, thank you. Is there any committee discussion on this resolution?
Mr. Chairman,
Mr. Gallagher.
while I appreciate Mr. Miller and everyone's hard work on this, the removal of the political parties, I absolutely agreed with. Having sat on those boards and seen the quality of the people that were getting appointed because of political parties. But I thought the framers really intended that there be a balance here, and I think the balance should be at the three-member, the fiscal officer, the county executive, the county council person being appointed by the council president. And that you received my proposed substitute resolution where I would add after, in the first paragraph, page 2, the underlined section which starts with which shall and ends with vacancy occurs. I would add the double underlined portion in the substitute resolution that would read, the council person appointed to the Board of Revision shall not be of the same political party as the county executive. In the event that there is no council person who meets the above criterion serving at the time of an appointment to the Board of Revision is to be made, the executive shall appoint an elector of the county, not of the same political party as the executive, subject to confirmation by the council. I think this would balance out any concerns regarding politics. It's at the top of the ticket, so to speak. I think it's fair and practical to do that. And I think it would flow nicely for the purposes that the framers intended. And I would pray upon my fellow council people to support this substitute resolution.
Mr. Chair.
Okay, Ms. Conwell, I'm sorry.
Missed the part where you said in the event that the council was of the same party.
It's the new resolution you have, that should have that in front of you.
We kill a bunch of trees.
Was that a motion, Mr.
Well-
Gallagher,
Well,
to amend?
we have, before we entertain that motion to amend, to interject the substitute, we're still open for discussion at this point.
We're just looking for whether you needed a second before you got to the discussion.
Well, this is a discussion on the current proposal, not on the substitute.
Okay.
Mr. Chairman?
Yeah, Mr. Miller.
Mr. Chairman, I would suggest that you entertain a motion to substitute, and then we can dispose of that question first, and then deal with the main motion.
Okay, very good. So, well, yeah, we've never moved actually the original. Well, the original's already in the record.
It's been moved.
So the original's already here. So there's a did you make a motion? So there's been a motion made to substitute resolution 2012-009 with the proposed substitute that's been presented before us as outlined by Mr. Gallagher. Is there a second on the? Second. Very good. The motion is made and seconded. Now we'll have discussion on the substitute.
Mr. Chair?
Yes.
I oppose the substitution. I've been consistent throughout these discussions that the politics should not be involved in a technical board such as this. There's no reason to involve politics, again, at any level in this when it's a technical board, and it's a lot different than the substantive board that Councilman Sharon brought up last time, which was, I believe, the
Department of Labor.
Yes,
Yeah.
you recall
And
that.
That's not political at all, I'm sure, is it?
So I just think this is a technical board, and when we start inserting politics, it actually makes something political that shouldn't be.
Mr. Gallagher.
I would concur with Councilman Simon by removing it at the level of the boards was the intent. And I would remind the council that this was the springboard of events for what happened 2 years ago, 3 years ago. And this, I think, we're sending a message that there is a balance, there is a check, there is equity at the top of this. And I think it takes the politics out of the bottom of it, which is where all the friends and relatives were being placed. This puts it at the top where we're at. And unfortunately, whether we like it or we don't, we are political animals, and we're in a political process, and we're in a political world. And the framers did put this in here to surgically remove that totally, I think would just not send the right message. However, vote your conscience.
Thanks.
I know
And
what
just
you're
one
saying.
comment, and I know what Councilman Gallagher is saying, but it's not the party that created the corruption. It was the corrupt people, and we have an inspector general now. We have very strong rules and code of ethics that would prohibit the patronage and the hiring of your sibling without disclosure. All that's been in place, so we've put all the safeguards in place. We don't need to add it here politically.
Mr. Chairman.
I'm sorry, Mr. Germana.
Mr. Chairman, I agree with Councilman Gallagher. The fact that I agree, having gone through trying to hire the Board of Revision, the political part, we want to have the most qualified people on the hearing board. And I think having balance at the appointment part is in keeping with what the intent was with the charter in the first place. So I think this makes sense. I think having balance at the top will enable this thing to get passed.
We'll go Mr. Schron. I'm not sure who. We'll go Mr. Schron and then Mr. Miller. Okay.
Mr. Chairman, and my colleagues, the Board of Revision amendment is a comprehensive correction of serious problems in current language, of which the political party question is just a small part. And I think we need to, each of us vote what we think and take our best shot on the political party issue, but then move it forward. However, I think there are some problems with this particular amendment that my personal preference would be that the substitute not be accepted. And number one, that the statutory Board of Revision is primarily administrative in nature. Second, that under the substitute, there could be times where we would not have a council representative, and I think it would be more important that council be represented than the political party issue. Third is that it could prevent the council president from appointing a council person who is really well qualified in this particular area. And finally, if the executive appoints a member of the opposite party as fiscal officer, as we have now, the substitute would require 2 out of the 3 members to be of the opposite party from the executive, which would be more than necessary. Thank you.
Mr. Schron.
First, I would like to congratulate Mr. Miller on all of his hard work and laying out this corrective changes and qualifications. And as Mr. Miller points out, that the decision as far as the political party is a vote of conscience. Because of that, I think that the folks who put together the charter had that same conscience vote when they made the suggestions and when the people of this county voted for it. And so it seems to me that within less than 18 months, we're recommending a significant change away from that, and that we somehow think that the 11 of us, although we are elected, are not of a political nature in our decisions today. It is as a result of the significant problems that the Board of Revisions had that probably drove us to this whole change of charter government in the first place, or one of the big elements within that. And as a result, I think that we're discounting all that took place before this, and to build that one piece of safeguard in there to have 2 different political parties at least being represented, and recognizing that when you have almost a single party rule, the risk is that you will drive to potential problems like we had in the past. And so as a result, though I congratulate Mr. Miller on all of the rest of the changes and would wish that that was a separate standing alone vote that did not pull that component out, I believe that we're slapping the face of all those folks who did the work before us, with the exception of pulling that piece out. I would suggest that if you sent this to the Charter Review Committee, I'll bet you would find that that provision would remain in there, and all the rest of this hard work that Mr. Miller has put forth would be adopted in total, and they would leave that component still in place.
Mr. Gallagher.
Just to Mr. Miller, in this proposal, the council will always have a seat. The executive would cede his position if there was a conflict.
Okay. Very, yeah, Mr. Miller.
Can I have a copy of the substitute? It says, in the event that there is no council person who meets the above criterion, the executive shall appoint an elector of the county not of the same political party as the executive. In that case, the council would not have a representative. You'd have the executive, the fiscal officer, and the appointed elector.
The executive would cede his position and appoint someone from the opposite party, not the council.
Mr. Chairman.
Mr. Germano.
Well, let me just think this through. I was going to say something.
No, that's fine.
Mr. Miller, except that it's not perfectly written, would you have a way to write this differently for that the executive would clearly cede his position?
Mr. Chair, if I can, before we get into the technical amendment of language, why don't we see if that would affect the outcome anyways? I mean, if we're changing language, I'm not sure that there would be support even in that case.
Well, that's an assumption on your part, and I would appreciate, some time here.
Well, I just thought we could all talk about it.
I appreciate that.
That's all. I'm not making an assumption. I just wanted to hear from my colleagues.
Well, that's what
Okay,
we're doing.
Let's do that. Well, I'm going to give a little liberty here and allow the author of the amendment to provide some clarity as to his intent.
In the event that there is no council person who meets the above criterion, serving at the time of an appointment to the Board of Revisions is to be made, the executive shall, in his place, appoint an elector of the county not of the same political party as the executive, subject to confirmation by the council. Would that be a little clearer? It probably would be in it.
Mr. Gallagher, what would happen if council wouldn't confirm the person?
If the council,
Wouldn't confirm the person?
then they'd pick another person.
Then council doesn't confirm them.
They pick another person like the sheriff. We could go on all day.
Okay, so just so I'm clear, so we have a substitute resolution that's before us that's been moved and seconded, and there is a possible amendment to that substitution. And Mr. Gallagher, can I just have the language again?
Why don't we just call the roll on it, like Ms. Simon says? If it's accepted, we'll substitute the language. We'll amend the language,
Okay,
if it's accepted.
so we'll take a vote on the substitute. Well, there still may be discussion on the substitute before we take a roll call on the substitute, because I have a question that I've yet to ask. And that question is, it appears that there was language in here to remove the party affiliation from the hearing boards. Has that language been removed? Because the current charter I'm not even referring to the current charter at this point. Has that been eliminated?
Mr. Chairman, yes, the amendment removes the requirement for the political party provision regarding the hearing boards.
And just so I'm clear, and that was, Mr. Schron, was that your concern?
Yes, it was support for the language as Mr. Miller has put forth, except for that provision, and as a result, I will be voting against it if it carries that elimination.
Right, and okay. Okay, so we will then take I'm sorry, Mr. Germana?
You know, I think what we're saying is that we want to have some balance at the appointment level, which is the Board of Revision.
The statutory board, correct.
Right, and so if all the council, the executive, and the fiscal officer were the same party, that the way Mr. Gallagher has written this, it would work. Because if you didn't have a council person that would be of a different party, then you'd have to get an elector. So this does work to have some type of balance. The other way that's not contemplated is when you have a fiscal officer of a different party than the executive, then the council person could be the same party of either the fiscal officer or the executive. So all we're saying is that there should be some balance at the appointing.
Mr. Gallagher?
If the fiscal officer has already been appointed and confirmed by the council, so you kind of take him or her out of the equation, and that brings the elected executive and elected council. And that's where I believe the balance should be. And again, it's kind of belt and suspenders, I understand that, and it may be a little quagmire-ish, but I think to take out the total intent of the framers, and they were very careful to put this part in there because of the unfortunate experiences. I won't go as far as Mr. Schrein, but I just think it's something that the people want.
Let me just make this general statement. I'm sorry, Ms. Conwell, did you have a statement before I make mine?
I just think that the statutory board should be looked at different than the hearing board. So I think we got a different issue going on there. Whereas the framers, the transition group wanted this for the hearing boards. Now we're talking about the statutory board, which is something separate. So my take on it.
Okay, look, that's fine. But before I do that, I just want to make it clear. If this passes as is without the known pending amendment and the amendment fails, then this would be the legislation that is adopted, at least the passed version. So I just wanted to make that clear. By not making the amendment to the resolution prior to the vote on the resolution, there is the risk that the amendment will not pass.
I think we need to vote on the amendment first.
Okay, that's fine. And so we'll do a roll call vote on the amendment. No, I'm sorry, we're voting on. Right, we're voting on the proposed substitute resolution at this time. And that motion's been made and seconded. And so we'll do a roll call vote on the proposed substitute resolution.
By Gallagher.
By Mr. Gallagher, correct.
Calling the roll, Ms. Conwell? No. Mr. Jones?
No.
Mr. Rogers?
No.
Ms. Simon? No. Mr. Greenspan?
No.
Mr. Miller?
No.
Mr. Brady?
No.
Mr. Germana?
Yes.
Mr. Gallagher?
Yes.
Mr. Schron?
Yes.
Ms. Connolly?
No.
Motion fails.
I'd withdraw this substitute resolution.
All right, the substitute resolution is then withdrawn. The resolution before council is the original proposed resolution. Mr. Miller?
Mr. Chairman, I would move to refer Resolution 2012-0099 to the full council for second reading.
And
Very good. Motion's been made and seconded. Any discussion on the motion?
Mr. Miller, Mr. Chairman, I just want to make sure, now, according to this one, I probably should be able to find it, you are taking out the political party qualifications for the members of the hearing board, is that correct?
That's correct. Mr. Chairman?
Yes.
Under this proposed amendment, there would be no reference to political party with regard to either the statutory board of revision or the hearing boards.
Right. Okay. Any further discussion? Okay, I will be opposing this as well, for the same reason that Mr. Schron stated insofar as the perceived original intent of the crafters of the charter. I am not there yet. Ms. Simon asked last time, what does there yet mean? That we are at a point in this county where political affiliation should not be considered. As I said, I would be in favor of a sweeping charter proposal to remove all party affiliations, including our own elected positions and that of the executive and the prosecutor. If we're truly intending to go there, then let's go there all the way, not halfway. So those are my general statements on that. Any other comment? Okay, hearing none, will the clerk call the roll for resolution? This is to move this proposal to the committee move it forward for second reading. Once again, let me just read this statement. I said I would read this statement, that we asked this question: does this matter provide clarity, and is this matter so urgent that the clarity sought in the resolution merits the consideration by the electorate this November? So as you cast your vote, consider that in your decision. Clerk, please call the roll to move resolution 2012-0099 for second reading.
Ms. Conwell?
Yes.
Mr. Jones?
Yes.
Mr. Rogers?
Yes.
Ms. Simon?
yes.
Mr. Greenspan? No. Mr. Miller?
Yes.
Mr. Brady?
Yes.
Mr. Germana?
Yes.
Mr. Gallagher?
No.
Mr. Schron?
No.
Ms. Connolly?
Yes.
Motion carries.
Okay, very good. That vote was 8-3 to refer to. Okay, very good. Will the clerk please read the next resolution, 2012-0100?
Resolution number 2012-0100, a resolution providing for submission to the electors of the County of Cuyahoga an amendment to Article 9, Section 1 of the Charter of Cuyahoga County, and declaring its necessity that this resolution become immediately effective.
Very good, thank you. I will ask, well, is there any public comment on this matter? Hearing none. We have two sponsors of this, Councilwoman Conwell and Councilmember Miller. Who wishes to be heard on this?
Mr. Chair, to my colleagues, the summary basically, under this amendment, council, rather than the executive, will appoint the members of the Human Resource Commission. And since the commission's function is to hear grievances of employees serving in the executive branch, having the members appointed by council will provide a better checks and balance. That was the basis of this proposal. Some of my colleagues, had made some suggestions. Wonder if council appoints 2 members, exec appoints 1, or vice versa. The difficulties in that, you'll have to start to decide which terms the council or exec will choose. You'll also have to make sure party affiliation doesn't have a conflict, because that part is in this section as well, and it was not removed. If council has a pick, another proposal was if council has a pick, exec has a pick, and maybe a third entity or outside member could be identified, that would create problems as well, in my opinion. this simply would just not give us the authority to do anything other than what the county exec has to do. He appoints, he hires, he disciplines, whatever. It would not change any of those functions. We're not trying to get involved in that in any way, shape, or form. This is just to have a fair perception for the employees that work for this county.
Very good. Before we have public or open discussion among council members, I want the committee of the whole to be aware, and you should have a letter that was sent to me dated July 6th from the members of the Charter Review Commission. I'm sorry, the Human Resource Commission. Each of you have a copy. July 6th letter, right? It's a single letter. So I just wanted to make, it was presented, and I wanted to ensure that it was presented to the committee for their consideration.
Mr. Chairman?
Mr. Germain.
I'm just wondering, it seems like the cost of the proposal is an issue. If we're going to have things on the ballot anyway, is there any extra cost just for, I mean, it can't be that significant, the cost to have this additional number 6.
Well, I'll defer that to Mr. Miller. You've done research on this, right? If we put one item on the ballot or 5, is there a cost difference? Or 0 if there are no items?
This is pretty complex, but my understanding is that being that this is an even numbered year where we have county elections anyway, that there would be no additional cost, provided that the amendments do not require that an additional page of the ballots be prepared. If the amendments do require that there be an additional page of the ballot, then there would be some additional cost, and we don't know whether 1 amendment, 2 amendment, 3 amendments, or 6 amendments would put us over that point, because it depends on exactly how many other issues and candidates and questions are on the ballot.
Okay, thank you. Well, further to that, and actually I was remiss, and Mr. McAleer worked for the Board of Elections. If the question then would come, if a municipality has an item on the ballot and one does and one doesn't, we might have an extended length ballot in particular municipalities and not in others. So the question may be, we may have a cost in some communities, but not in others. Is that? Okay, we're getting a nod, yes. Okay, so Mr. Germain, well, I was going to ask you, do you have any further comments to the explanation?
Well, I'm thinking there's going to be, I don't know if there's the requirement to have an ad with all the verbiage, but you know, actually leapfrogging away from the cost, I want to comment about the whole concept in itself. This letter, I don't think Councilwoman Conwell's purpose of suggesting this. I think we had excellent people that have been appointed. What this does is corrects and has balance for future appointments, because you never know who the next executive might be, and he may not pick he or she may not pick the same caliber of people on this commission. So in no way is this anything saying that we're not happy with these people. I think the whole concept of this is, hey, the charter, we could have checks and balances. So I support Councilwoman Conwell for that reason. And since we're going and correcting and improving the charter, I don't think the cost should be considered at this point.
Mr. Chairman?
Well, I'm sorry, Mr. Miller.
Mr. Chairman, I have a general philosophy that you can't have 12 people running the county, and that therefore it's my philosophy that whenever I think it's a close call, that I'm going to support the administration, and I'm mindful that the administration has come out against this amendment. However, in this case, I think it's not a close call. Prior to this regime, when there was a grievance, the appeal was to a state board which was entirely separate from county government. And there needs to be some way that the employees would know that when they have a issue that they're going to have a fair and independent hearing. I think that the current Commission has done an admirable job, but I think the problem of perception remains. And so I think this is a good amendment. It would provide a good checks and balance and help employees know that they have proper recourse if an issue arises. And so I'm a supporter of this amendment. Thank you.
I'm a supporter of this amendment for the same reasons as Mr. Miller, but I thought we were just discussing something else. We were talking about the cost of putting these things on the ballot. And my concern is that, I mean, I'm an experienced voter, and, you know, you have to read through all the stuff and make sure you understand it, and, you know, you look at the recommendations, and I know I got probably, you know, a dozen or so senior citizens or people that call me and say, you know, how do you vote on this? So we want to have enough things on the ballot that we have to have the important things on the ballot, but we don't want to have too many to confuse voters. Because these are very technical things the voters have to understand, and, you know, I don't think we can put, you know, 10, 12 things on the ballot because this would be confusing for the voters. So we want to pick the most important ones so that the voters can have an ample opportunity to, you know, go to the League of Women Voters and read the Plain Dealer or the Call Post or whoever they want to read to make their decision to vote yes or no.
Okay. Any other comments? Mr. Gallagher.
Thank you, Mr. Chairman. I agree with Mr. Miller that sometimes you have close calls. And when I had discussions with the sponsor, I kept asking, where's the problem? Is it broken? And how does it need to be fixed? And I think after a year and a half, it isn't broken. We're going on the perception that it may break, and therefore we have to change it now. I honestly see this as building a wall that I thought we were here to take down, because you're going to have the executive on one side eventually, if we're going on perceptions, and then us on the other with the employees somewhere in the middle. Usually, I would imagine if we appoint the hearing board, that phones will be ringing. So I don't support this as it is. I did make the suggestion to split the apportionment to the council and the executive. I thought that would be a fair thing, as opposed to building a wall of council with 3 appointed members from the council, maybe from the council, the executive, and an independent individual, but that didn't go anywhere. So I will not be supporting this, because I think we need to move forward with things that are broken, and this isn't broken.
Any other comment? On this issue, I see both sides of the argument. I wish there was someone from the HRC here to answer a question I have as to how the appointment process impacts their day-to-day ability to perform their job. So because I don't have that opportunity, I'll support moving this forward with the hesitation that I would like to have that question answered. So that's, hopefully someone will be here at the second reading meeting. So if there are no other questions on this matter, we have a motion. The item's been discussed. We don't have a motion. Okay, I'll entertain a motion to move Resolution 2012-0100. But I need to know what that motion is going to be. Or is it going to second reading? Is it going to Charter Review Commission? I just need to know where it's going.
What, I would like to make a motion to make that to the second reading.
Yeah, I'll second.
Okay, so motion's been made and seconded. We've had discussion on the motion. Ms. Simon?
I just want to say that I would have supported a hybrid appointment that Councilman Gallagher spoke to. I'm more comfortable with that because traditionally this is in the purview of administration, not council. And I don't know if it's council's role to start getting involved with these appointments, but I would feel comfortable with some kind of mixed appointment. That's my comment.
Mr. Schron?
I'm of the same ilk. I think that you start to move into the executive's leadership and hiring and responsibilities. You've really changed the core of what the charter is supposed to be, which is we're legislative and they're executive, and their job is to take care of the personnel matters. And as a result, when you start moving into this, we've now stepped into their what I think was the core change of this charter government. I would have supported Mr. Gallagher's bifurcated program, but unfortunately, the way it is, we've taken away the purview of the executive.
There still is an opportunity, just so the committee is aware, once it leaves this committee, for an amendment to come forward at a future time. I will say, I wasn't going to get into this discussion, but I will at this point. The purpose of the Human Resource Commission is to hear, among other things, appeals to matters under the executive council. Since our folks are not subject to HRC review, we would be the most independent body to make the appointments under that scenario, just as we make the appointments to the Internal Audit Committee. That is an independent body that we appoint to provide overview into day-to-day operations of the administration. I do understand where the perception could be publicly that employees who would have an appeal, since the executive and his staff are the ones issuing the discipline, might feel intimidated if the perception is that the HRC is comprised of executive influenced appointees. So I see both sides of the equation, but I don't think we should be at all standoffish in perceiving that this would be an encroachment upon the executive's authority, since we already do this with the Internal Audit Committee as well. So I'll end with that comment. But Mr. Germana, did you?
Oh, I just want to say that the logic about it's not broke, and my comments were it's not broke. I think we got an excellent group of people on the commission, but we don't have to wait until something breaks to fix it. If we can improve the charter, because it's not broke, but if we could approve it for balance and following the comments of Mr. Miller, this is not in any way anti-executive. I just think it's the balance, and we shouldn't wait for it to break. They have a different executive to make some bad appointments and have situations. Let's fix it now.
Very good. Mr. Gallagher?
I would support moving this to second reading, and I'll get together with anyone interested to maybe work on a substitute that may be able to take care of the perceived brokenness of what is originally here. And I think it could be fair, and having been an ex-employee, not of the county but in the state, I get it. I get why people might be a little intimidated, or they perceive intimidation in their heads going forward. So maybe we can make that a little bit better with a consolidated, equalized board.
Okay, very good. Mr. Schron?
And I can support bringing it out for purposes of the second reading, but if it's not changed by the second reading, I cannot support it in its final vote.
Very good. Okay, any further discussion? Okay, hearing none, we've had a motion that's been made and seconded. Will the clerk please call the roll on Resolution 2012-0100?
Ms.
And I'm sorry, the motion is to send it for second reading to council.
Ms. Conwell? Yes. Mr. Jones? Yes. Mr. Rogers? Yes. Ms. Simon? Yes. Mr. Greenspan?
Yes.
Mr. Miller?
Yes.
Mr. Brady?
Yes.
Mr. Germana?
Yes.
Mr. Gallagher?
Yes.
Mr. Schron?
Yes.
Ms. Connolly?
Yes.
And carries.
Very good, thank you. Madam Clerk, will you please read Resolution 2012-0101?
Resolution number 2012-0101, a resolution providing for submission to the electors of the County of Cuyahoga an amendment to Article 11, Sections 1 and 3 of the Charter of Cuyahoga County and declaring the necessity that this resolution become immediately effective.
I didn't know.
Thank you for reading that. Is there any public comment related to this item? Okay, hearing none. The sponsor on this item, Council President Conley and Councilman Miller, who wishes to address the committee on this?
The council president's the prime sponsor.
Okay, very good, thank you.
All right, thank you, Mr. Chairman. The charter provides that the council appoint an internal auditor. This is one of council's only appointments. The internal auditor answers to the council, but basically to the internal audit committee, which is made up of the fiscal officer who serves as the chair of the internal audit committee, the county executive, and council president, and two persons appointed by the county executive and confirmed by the council. The problem that we've picked up is that the term of the internal auditor is concurrent with that of the county executive, and it was a problem in terms of the appointment because we were delayed in getting the person appointed, and then we had difficulty hiring the person because they only had like 3 years left. And the change that was proposed is that the internal auditor's appointment would be a staggered appointment, so that their reappointment would come up in the middle of the term of the county executive, so that we could get that person either reappointed or appoint a new person. So the problem is now that if at the end of the current executive term, that person, we will be without an internal auditor, and it could be some months before we get that person reappointed. So we'd like to have continuity of this function, very important function of government in terms of internal auditing, and amend the charter so that the term will be staggered.
Okay, very good. Is there further discussion on this?
I should say also, it also provides that there is a way of removing a person of the appointees. We could just have someone that moves out of the jurisdiction or just doesn't show up. I mean, and I think it says for cause. So we don't anticipate that we would have a necessity for removing our current appointees who are very fine individuals, but we need it for the future that just in a remote case, someone had health issues and wasn't able to attend, or like I said, moved out of the jurisdiction or just didn't show up. We'd have to justify for cause the removal, but now at least we have a provision that allows for us to do that.
Okay, very good. Any discussion on this item? Mr. Miller.
Mr. Chairman, first of all, I strongly support this amendment, as I feel that it deals with a number of structural problems and would provide for a smoother operation. I would point out that at the second of our forums that we held with the public, the suggestion was made that we might have the two citizens that are appointed serve on staggered terms rather than having those terms end at the same time. And a substitute was prepared that we have in front of us that does that. I'm not going to move the substitute at this time. I'm going to leave it to the council president whose amendment this is, but I want to bring it to everybody's attention so that if we want to do that, we can move that forward.
Yeah, Mr. Mill, why don't we get that together for the second reading? I don't have a problem with staggering the terms.
Mm-hmm. Okay, fine.
Okay, very good. So there'll be no substitute proposed today.
Right.
Okay, very good.
Fine.
Any other comment from the committee? Hearing none, I will.
I'd like to move then that it be referred to the council for second reading.
Second.
Very good. Motion's been made and seconded for second reading. Any discussion on the motion? Okay, hearing none, I'll once again I don't need to read the statement. Does this provide clarity, and is this of urgent nature as we make our decisions, please consider that. The clerk, please call the roll.
Calling the roll for resolution 2012-0101. Ms. Conwell?
Yes.
Mr. Jones?
Yes.
Mr. Rogers?
Yes.
Mr. Simon, Ms. Simon? Mr. Greenspan?
Yes.
Mr. Miller?
Yes.
Mr. Brady?
Yes.
Mr. Germana?
Yes.
Mr. Gallagher?
Yes.
Mr. Schron?
Yes.
Ms. Connolly?
Yes.
Carries.
Very good, thank you. Will the clerk please read the title, Resolution 2012-0103?
Resolution number 2012-0103, a resolution providing for submission to the electors of the County of Cuyahoga an amendment to Article 2, Section 2.031 and Article 9, Section 4 of the Charter of Cuyahoga County and declaring a necessity that this resolution become immediately effective.
Very good, thank you. Before we have public request for public comment, additionally, there was an email received to council regarding regarding these two items. I'm sorry, regarding this item. It was from Sally Weindorf. I believe council was submitted a copy of that email. Is that correct?
Shelley McHugh.
I've seen it.
I'm sorry. I'm sorry.
She has both. Maybe she got married.
Yeah, Sally McHugh, I'm sorry. I was reading the email address. Just want to make the committee aware it was submitted and for your consideration. Okay, is there any discussion on this proposal, on this resolution? Ms. Simon?
Mr. Chair, I think this makes sense to be clear about the employees of the county and that we should have a central human resource place where all decisions are made opposed to what was going on before. So I think this makes sense and consistent with what we want to do with the new government.
Okay. Madam President.
I have some issues with this amendment to the charter, and I'm still seeking clarification. One of the aims of this government was to have a countywide workforce, a workforce that we did not have people working for the auditor and working for the treasurer, and that people work for the county. And my concern about this particular amendment is that, in a sense, we are going back to that placing, and I'm really tired of this term about putting people in silos. It's really, we've kind of worn it out. But we're putting people back in these divisions, and if you are a secretary who answers the phone and types letters, you can do that in any department. So you should be able to bump someone if there are layoffs. So I'll go ahead and vote for this to go for second reading, but I still continue to have real serious reservations about this. It has not been clearly defined to me. I mean, first of all, we've done a lot of layoffs here, but people who have, invested their life and their career into being county workers, they should be able to maintain their jobs. Now, we could do this and we could correct these problems by classification. If you're a sheriff deputy, you can't go over and bump the court psychologist. But if you are a worker that has skills that are universal, then I don't know why you're stuck in this one division. So I'd just like to have some additional clarification on this, because as I understand it now, I'm not in favor of it.
Do we have anyone? I
understand if this is an administration proposal, there's no one here from the administration except the law director, and the law director is supposed to be our lawyer and the executive's lawyer, so I don't understand how he comes in.
Our liaisons here.
Now, if Melvin get prepared to speak on this, because there's no one from the administration here to speak on this.
Well, and that's actually, Council President, that's actually where I was going with this. I deviated from my protocol as to ask if there was public comment. So I'll ask, is there public comment?
The law director speaks on this. He's our lawyer too. I mean, so how does he speak on behalf of the administration?
My next statement was going to ask, would the sponsor present? And the president's correct insofar as the law director making the presentation on behalf of the administration. If there, my personal opinion is if the sponsor's not here, the sponsor doesn't feel this is meritorious enough to move forward, I'd almost defer it to the CRC. But I don't, Mr. Davis, are you prepared to discuss this on behalf of the administration?
I mean, if you got a chief of staff over there, you got other people, administration, none of them are here.
Mr. Chair, as the law director has actually stated before in previous meetings, this actually isn't something that's coming directly from the administration. This is actually something that the law director from Boots on the Ground was dealing with and actually brought forward. So he said, okay, this is an issue, and he brought it forward, and the administration sponsored it to go forward.
Okay, Mr. McClure. Thank you for clarifying that, Mr. Davis.
No, and precisely on this amendment, that is clearly, this amendment is the byproduct, is the birth child of Ed Morales in my office. This is not an amendment that the administration was concerned about or brought to our attention. This is an amendment precisely that the law department brought up to the administration as something that needed to be fixed, and the administration was willing to sponsor it. But let me clarify one issue in response to what Council President said as to the intent of this legislation or this amendment. This is actually almost the exact opposite of the issues that we were having. In terms of the silos, that actually already exists in the charter in 9.04. The charter already says that the county executive and the officers, offices, agencies, departments, each is an appointing authority. So the county charter already makes each one of those their own appointing authority for purposes of layoff and the bumping rights. The purpose of this amendment is the situation that we had after the creation of the charter is, if I may step back a bit before the creation of the new county government. When you had the Board of County Commissioners, there was something that used to be called the personnel agenda. So somebody needed to be disciplined in the Health and Human Services or one of those departments. The personnel agenda would be prepared. It would go before the Board of Commissioners, and they would vote. They would vote on it. After the consolidation of the county government, the way we read the charter is that that's the same situation that happens now. The county executive is what used to be the administrative part of the Board of County Commissioners. The same situation would happen. You have a discipline in Health and Human Services, or you have a discipline in the Sheriff's Department, or you have a discipline in the Fiscal Office, that at the departmental level, the discipline is recommended, then the personnel agenda is sent to the executive, and he would sign it off. Where we started having the issues is we were having the argument made because in section 2.03 of the charter, it says that the county executive has the power to appoint, suspend, discipline, remove all county personnel, and then including those appointive officers provided for in Article 5. But then you read the except provision, except those who, as provided by general law, are under the jurisdiction of officers, boards, agencies, commissions, other than the Board of County Commissioners. So the argument was made that if somebody is disciplined in Health and Human Services, the discipline authority, the ultimate discipline authority is the county executive. However, if somebody is disciplined in Wade Steen's shop in the Fiscal Office, the discipline authority is Wade Steen and not the county executive, and the county executive has no say in the discipline of that employee. This is not how we read the language of the charter, because there is no such thing as an appointed sheriff under general law. There is no such thing as an appointed fiscal officer under general law, but that's the interpretation that we were faced with, and that's what seeks to clarify is over those issues. In the same way that you used to have the personnel agenda go before the Board of Commissioners for Health and Human Services and Department of Development, we're doing it the same for all the county employees in the executive branch. What we wanted to clarify then in section 9.04 is, because we're changing that to clarify that there is no issue with it, we didn't want somebody to come back and change what 9.04 already says as to the discipline, the different silos. So the intent of the revision in 9.04 to clarify that because we're clarifying section 2.03, we didn't want that to be interpreted as if we've made the entire county one appointing authority. But that's the intent of here, is not to create silos, it's actually to get us out of those silos.
Okay, Mr. Brady. Oh, yeah, Mr. Brady, I'm sorry.
Thank you, Mr. Chairman. So do I understand that as our legal counsel, you are advising us to put this charter amendment on the ballot?
Yes, I can very validly say that this is an amendment that was put forth by the law department. The law department is advocating for that there is an issue, an area of ambiguity in the charter that we're asking that it be clarified. Ultimately, what the resolution is, I mean, you know, this, let me put it this way. This is the amendment that's put forth that we believe clarifies the charter to the way that we read the charter to be. Now, so yes, I would be advising the council to put it forth. If council comes up with a different, you know, you could have different theory, like some council, you know, may want to go in a different direction, clarify it in a different direction. That's your legislative choice. But this is, in my mind, this is clarifying what the intent of the charter is, what everybody thought they were voting on when they voted on the charter.
Thank you for your advice.
Mr. Germana?
Thank you, Mr. Chairman. Your explanation went to the disciplining, and I can understand that. But I think this letter from Sally McHugh and in the summary, talking about bumping rights. Now, that bumping rights has nothing to do with discipline. That has to do with seniority. Is there an issue? Can you explain that, the bumping right side of this?
Yes, and under the current charter, and we've had a number of cases, and actually we've been succeeding in a lot of those cases, is the way that the charter works right now is each department is its own jurisdiction. So you lay off somebody in public works, you look to the seniority in public works. You lay off somebody in the fiscal office, you look to seniority in the fiscal office. So we haven't had any issue with that. What we were worried about is because we're changing 2.03, that the argument would be made that the change that we were making in 2.0, the point we were worried about is the change that we were making in the discipline provision, that somebody would interpret that as if we were changing the article about the layoff jurisdiction. So we wanted to clarify that the change there is not intended to change the layoff jurisdiction. It remains, each department is its own layoff jurisdiction.
Can I ask a question before I entertain other questions? This is somewhat of a question. If this moves forward and appears on the ballot, all of us when we were candidates had to come up with 30-second speeches as to why someone should vote for us. What's the 30-second speech on this one?
I think it's the treatment of all county employees to be the same, whether you work in the sheriff's department or you work in the fiscal office or you work in health and human services. Wherever you are, you're under the same procedures for hiring, firing, discipline, layoff, and the same ultimate decision-making authority over all of those. That's what this is.
So it's a standardized HR protocol, is what you're saying?
For all of the county employees. The ones that used to be under the former elected officials, that the intent was to bring them in under the county executive to be within the executive branch, not that they're still separate to different procedures and different appointing authorities just because they were under those.
Madam President?
I have a question. Say the Soldiers and Sailors Monument, they hire an executive director and they hire some people, or the Veteran Service Commission. These are county employees, but they're hired by, or I don't know who else, somebody like that. It's like a separate board. Would those people come under this?
No.
No, they would still go through whatever procedures that are the bylaws of that. Okay, all right.
We are talking about the sheriff, the public works, basically the former elected officials that came on, the coroner, the medical examiner now, the public works director, the former engineer, the sheriff, the former auditor, treasurer, the former auditor and recorder, who's now the fiscal officer, and the former treasurer, which is now the treasurer, that those are under the executives. They're in the executive branch.
So I just like to repeat Mr. Greenspan's question. When somebody asks me for the 30-second soundbite, how do I explain this? I mean, if I'm working in the coroner's office and I'm answering the telephone and typing letters, and I'm supposed to be laid off, why can't I bump somebody in social service because I can answer the telephone and type letters?
that becomes a policy question. I mean, I think the simple, that's not the issue. Let me
Okay.
clarify that that's
Okay.
not the change that the law department is advocating. That's the reason we put that in there is to make sure that the change in 2.03 didn't change what already is there. I think the answer to that question is that's how it is right now. That's how it's always been.
And
And-
it will not be that way if we pass this?
Say it again?
It will not be that way if we pass that?
You will not be changing the fact that it's still its own jurisdiction for purposes of layoff.
So why can't you just label me like, secretary, medical examiner? Can't you just do it by, why do we have to have this charter amendment? Can't we just give people job classifications?
This would not, yes, and then this would not change any, again, the way the system works right now, and quite frankly, it's not that much different from how it worked under even the former system, is you had the corner office, and it was its own appointing authority, it was its own jurisdiction. You had the auditor, it was its own jurisdiction, you had the treasurer, it was on its jurisdiction, the sheriff was its own jurisdiction. And when you were laid off from any one of those divisions, you could not bump anybody anywhere else in the county. When the charter got adopted in section 9.04, it expressly says that every one of those is still their own jurisdiction. It did not change that. What it changed is it made the elected officials to come under the county executive, that those became executive employees. So that's so I guess what I'm saying is somebody can make the argument for changing that. What we're trying to do here is that's not a change that we're making. We're keeping the status quo. It was more of a linguistic clarification that we're making because we're changing section 2. We're keeping section 9 to be the same.
I may not be the sharpest tack in the drawer, but I've been, I'm still confused, so. I don't know. I'm still confused.
Mary, I would agree. Any other questions? All right, we're at the point where a motion should be made. Does somebody want to make a motion?
I'll move that this amendment be moved to the council as a whole for second reading.
There's a,
Full council.
Full council.
okay, there's a motion on the floor. Is there a second to move this to council for second reading?
Second.
Yeah, motion's been made and seconded. Any discussion on the motion?
Chairman,
Yep, Mr. Brady.
I just want to indicate that I'm undecided about this issue, but will support moving it forward.
Mr. Miller?
Mr. Chairman, I'm in the same place as Councilman Brady. Of the 13 amendments, I think that I have the least understanding of this one. And so, but I'm willing to move it along and make the final decision later.
Okay.
I'll amen to what Mr. Miller says.
I'll have the same opinion. I think we need clarity, and we need to have the county executive sit there and tell us why this is administratively to his advantage to operate, and why he wants to see this in place in support of what the county, what our legal advice has been put forth.
Why we move it forward?
I mean, I as it's right now, I can't sell this, so I don't know how to, I can't, I'm not even sure I could support it right now, to be honest with you. I would actually, well, if it passes, it passes. I'm not going to support it. If it doesn't, I'd refer to the CRC.
Why are you looking at me?
I'm just looking. Okay, will the clerk please, we'll do a roll call vote on Resolution 2012-0103.
Ms. Conwell?
No.
Mr. Jones?
Yes, I'll support moving forward.
Mr. Rogers? Ms. Simon?
Yes.
Mr. Greenspan?
No.
Mr. Miller?
Yes.
Mr. Brady?
Yes.
Mr. Germana?
Yes.
Gallagher?
Yes.
Ron?
Yes.
Ms. Connolly?
Yes.
Motion carries.
Thank you. That was 9-2, correct? Very good. Moving, yes, Mr. Germana.
Somehow this is perceived as an attack on public employees. And, you know, I just hope that the administration can debunk that, okay? Because, you know, my vote was not an attack on public employees. What we need to, I think the public employees are being misled on what this means. So we need to say that this, you know, our council vote is pro-public employees. So we'd like to know what the benefit is to public employees. We're not attacking public employees for moving this forward, and we just need to clarify that.
And if I may, Mr. Chairman, Mr. Nani just explained something to me that I didn't understand what this. I read this and it didn't make any sense to me, so I didn't understand what it was.
You know how we feel.
No,
No, this is the.
no, it's the. I think what this is talking about is under the Board of Commissioners, under they treated all the people that were under the Board of Commissioners to be one layoff jurisdiction. But the charter already changed that in section 9.04. It made each department its own jurisdiction. So nothing that this amendment does changes this, because what this amendment does is it keeps what the charter did. And all this, you know, what she's asking for is to go back to before the charter went into effect, not a change from the current charter to the proposed amendment.
Okay. All right, thank you. Okay, will the clerk please read Resolution 2012-0104?
Resolution number 2012-0104, a resolution providing for submission to the electors of the County of Cuyahoga an amendment to Article 5, Section 2, Section 7, and Article 10, Section 1 of the Charter of Cuyahoga County, and declaring the necessity that this resolution become immediately effective.
Okay, very good. Is there any public comment related to this item? Okay, hearing none. Anyone from the administration here as sponsors to address this item, other than Mr. McCloof?
Mr. Chair, this legislation here does two things. The central thing that it does is it consolidates all of our finance operations into a departments of finance and operations. So you'll have our fiscal officer, you'll have procurement and diversity, and the treasurer, all within the Department of Finance and Operations, and all underneath the fiscal officer. The treasurer still remains there. The treasurer is not eliminated in this position, in this proposal. It just simply comes underneath the jurisdiction of our fiscal officer. Another thing that this does is it also gives the council, it appoints a deputy fiscal officer for procurement and diversity and allows the council to actually confirm that individual.
Okay, thank you. Thank you for that. Discussion of the committee.
Mr. Chairman.
Yep, Mr. Brady.
My position, we've had this discussion at some length with Mr. Steen and tried to, my position is that I think we should send this to review by the Charter Commission.
Very
it's
good.
A structural change. It's fairly significant, and I'm not prepared to. It's not a motion. I'm expressing my opinion because at some point making a motion if people don't agree with me.
Okay. Is there further discussion?
Go ahead, Sam.
I listened to Wade Steen at a couple committee meetings, and I think this makes sense for just streamlining operations, and I think it gives us the ability to have some input into the procurement person. I think this makes sense. It's just carrying on the mission that we were put here to do. So I support sending this to the second reading.
Okay.
Mr. Chairman.
Hold on, I'll go to President Conley. I'm sorry.
Mr. Chair, I'm in a position of this is one of those, if it ain't broke, don't fix it. I don't think that we need to make a change here, and if there should be a change, that the Charter Commission should review it. I believe there is merit to having the treasurer have an independence here, and I don't see why we have to change the treasurer to put him under the fiscal officer. There's an advantage of checks and balances having him as an independent person. So at this point, I'm opposed to it.
Okay.
And I mean, I'm opposed to it and putting it on the ballot, and that we should go to the Charter Review Commission.
Mr. Germain.
And once again, there is no one from the fiscal office here. There's no one from the administration to speak on behalf of this. We've noted this meeting has been noticed. Everyone should know, if you're for something, you should be here to speak for it.
Mr. Germano?
Mr. Chairman, I'm actually going to be talking on both sides of this. So I do understand. So I don't want this to be interpreted like I don't understand. I agree that clearing this up, everything fiscal, people should be working in a coordinated way. And we don't need to have a difference between a treasurer and a fiscal officer working against one another. So for that reason, I think this should move forward. On the other side of this, when I was at the Shaker Heights focus group, the one lady in the focus group from the League of Women Voters brought up the fact that Treasurer Wakakis, who had a big part in discussing the formation of the charter, felt there needed to be some type of independence for the treasurer. So I'm in favor of moving forward, but like President Connolly said, I'd like to hear that argument, if not from Rakakis himself, from the administration to treasurer, if there's this need to have this independence or not. So without an explanation for that, I'm in favor of consolidating this because things fiscal shouldn't be working against one another. We're talking about management and budget comes under the fiscal officer, and if the treasurer who does the investments with the investment board and so on is working against the budget matters and so on, you're possibly breaking something. There should be checks and balances, but you can't have the fiscal operation of the county working against one another. So I'd like to hear more information. I'm in favor of the concept of keeping things fiscal coordinated, but I'd like to hear more why the treasurer should be have some independence.
Mr. Miller, then Mr. Schron.
Mr. Chairman and my colleagues, I've given long and hard thought to this amendment, and I've decided I am in favor of it. The wrap on this amendment is that there needs to be a checks and balance between the treasurer and the fiscal officer, but I don't think there's much check and balance to be gained because of the fact that they both report to the executive, so they're not really independent. And however, there is operating efficiency to be gained in that the employees of the two offices perform some similar functions and some useful circulation among the offices could be achieved. So I'm a yes.
Mr. Schron.
Thank you, Mr. Chairman. From a fiscal and financial standpoint, it does not make sense to me that the CFO or the CEO, who has responsibility for the CFO, would not have the same responsibility for the treasurer, that those functions, the treasurer is really just an investment arm of the county government. However, in keeping with at least what I believe to have some integrity in my position, is that people put forth in the charter that is a separate standing check and balance. So therefore, I believe it belongs back at the Charter Review Committee, just as the political party issue, if we want to have that, belongs back at that level. And so from a consistency standpoint, I support the idea of Mr. Brady that it belongs back at the Charter Review. If they believe that it still needs to have that separate check and balance, I would probably still disagree from a fiscal and financial standpoint, that I think operationally it makes more sense to have it all combined. But I don't believe that this is a place to, I don't think it falls into the category of exigencies that we need to make a quick change fix. It was put in the charter as a cross-check and balance, even though my business side says all these are merged functions in a business, you would not see these, you wouldn't see our treasurer, you wouldn't see our controller, you wouldn't see all those as separate entities. They all sit underneath under the CFO. For some reason, the folks who put this together for the charter felt that it needed to have a check and balance, and for that reason, I would agree with Mr. Brady. Rather than support it in this condition, I would support suggesting it go back to the charter review and ask for that. Which doesn't mean that I'm against the idea, but it means I would rather be consistent with my philosophy that there are core pieces that are written in this charter, and I can't say we should knock them out here within 18 months because I don't think the agencies are there for this.
Great, thank you. I would agree with Mr. Schron's position insofar as deferring it to the CRC. Being a CFO, I get how operationally this works. The duties of the treasurer and the other fiscal offices are not in competition with one another. They actually should, as Mr. Germanis said, work more closely together and not against one another. The other thing that's important in this, which we haven't touched upon, is right now the purchasing department is an executive, independently appointed position or hired position. This amendment would have the director of OPD be an appointed and confirmed position. So it's actually something that is not currently in our charter. I go back to my original statement, the one that I try to ask before we vote on everything. Does this provide clarity to the charter? I don't think there's anything ambiguous in the charter about the current reporting structure. I think this would work better, and I'm in favor of this in concept. But I don't see this as necessarily something that's urgent for us to put on the ballot. And so it fails my second test of urgency insofar as providing services to the residents of the county. So I would support a motion to defer to the CRC.
So move.
Okay, so motions in a couple seconds. So there's a motion right now, and so is there to defer this to the CRC, to the Charter Review Commission. Is there a second? I'm sorry, there's been a second. Is there further discussion on the motion? Hearing none, will the clerk call the roll for a motion to defer this item to the Charter Review Commission?
Ms. Conwell?
Yes.
Mr. Jones? Yes. Mr. Rogers? No. Ms. Simon? No. Mr. Greenspan?
Yes.
Mr. Miller?
No.
Mr. Brady?
Yes.
Mr. Germana?
Yes.
Mr. Gallagher?
Yes.
Mr. Schron?
Yes.
Ms. Connolly?
Yes.
Motion carries 8-3.
Okay, very good. All right, those are all 7 items today that were on the agenda. Keep in mind that we still have 3 that will be coming back from the committee meeting that we had today for a committee of the whole meeting. Just to review the calendar quickly as to where we are in the process, these items that were voted out today, and there were 4 of them that will be presented tonight and read for second reading. Those are resolutions 0099, 0100, 0101, and 0103 will be read for second reading. The other items, so that's 6, that's 4 that are moving forward. 5 we have deferred to the Charter Review Commission of the original 10, and 1 was partially absorbed into another item and eliminated, and the other component are eliminated. This doesn't mean, I think we heard today, that the 4 that we've agreed to move forward today for second reading are in any way approved for adoption. I believe there's still a number of questions, almost on each of them, that will need to be answered between now and the August 14th third reading of these items. Further reviewing the calendar, as I said tonight, there'll be a second reading on the 4. August 14th, we will have a committee of the whole item for the 3 items that were presented in committee today. They are being presented tonight for first reading. And if our calendar holds true, on August 14th, we will have a third reading on the 4 today, and on August 28th, will be the third reading for any, if any of the items that were presented today move through the process. I want to thank the committee, especially those on the Charter Review Committee. We've been here since 11. This has been, I think, a very worthwhile process. There is no way that anyone could make the statement that these were not publicly vetted between the public, the 2 town hall meetings, and the at least 4 public opportunities for comment. These have been open and will continue as we move through our second and third readings to discuss these in the public view. Moving along the agenda, if I can find my agenda. Okay, is there any miscellaneous business before the committee? No. Is there any public comment unrelated to the agenda? Okay, no one has signed in. Okay, then we will stand adjourned. It is 10 minutes till 3. Thank you.